Part 82 of the Chronicles of Crime, Volume 1, by Camden Pelham. This LibriVox recording is in the public domain. Part 82. Joseph Blackburn, executed for forgery. Part 2. The evidence for the prosecution having been concluded, Mr. Scarlett rose and said, "My lord, I have two objections, which I will submit to the consideration of your lordship, which will, as I conceive, be fatal to this prosecution. There are two facts which the prosecutor is bound to make out before he can substantiate the allegations in this indictment. The first is that the die or stamp, respecting which the forgery is alleged to have been committed, was a die used by the direction and under the authority of the commissioners of the stamps. Now, my lord, I contend that there is no evidence of this fact to go to the jury, because I confidently submit to your lordship that parole evidence, which is all they have offered, is not admissible under the circumstances which have been given in evidence, because it is an axiom in law that the best evidence must always be given which the case will admit of. Your lordship has heard from Mr. Cappan that the stamps authorised to be used by the commissioners were in their presence impressed in a book. This book has not been produced, and as no evidence has been given to show that it was lost or destroyed, parole evidence was not admissible to show the nature of its contents. That it is an essential part of the case that the die should have been directed or authorised to be used by the commissioners of stamps is evident from a reference to the 52 of the King, section 7, which states that if any person, after passing of that act, shall forge or counterfeit, or cause to be forged or counterfeited, any mark, stamp, die, or plate, which in pursuance of any act of Parliament shall have been provided, made, or used, by or under the direction of the commissioners appointed to manage the duties on stamped paper, and so on. Now, my lord, what I contend for is this, that the entry in that book is the only proof that this die of £2 was used by or under the direction and authority of the commissioners, and that this entry can only be proved by the production of the book itself. Supposing, my lord, that the book had been produced, and that upon inspection it should turn out that there was no stamp of £2 inserted there, in this case your lordship must allow that the prosecution would fail. But as the best evidence that it does contain this entry has not been given, it must be presumed in favour of the prisoner, that the book does not contain this entry. Had there been a written order in the usual acceptation of the term by the commissioners for the use of such and such stamps, your lordship would not have admitted parole evidence to be given of the contents of this order, unless satisfactory proof was given that it was destroyed or could not be produced. And I humbly submit to your lordship that the entry of the impressions of the dies in this book renders it completely of the nature of a written document, and places it within the same rules of law. I therefore humbly submit to your lordship that there is no legal evidence to go before the jury on this material allegation in the indictment, and that the prisoner is entitled to be acquitted. Mr. Justice Le Blanc: I think there is evidence to go to the jury. The commissioners gave their order by parole. They did not give a written order. Mr. Scarlett: the directions to the officers to impress the stamps in the book was certainly by parole, but I humbly submit to your lordship that when the impressions were made in a book, that book must be considered in the light of a written order. Mr. Justice Le Blanc: I cannot take it to be an appointment in writing, and I consider the evidence which has been given as to the use of stamps as perfectly admissible, and as proof to go to the jury. His lordship having overruled this objection, Mr. Scarlett said, I will now trouble your lordship with respect to my second objection, which I consider as the most material and as decisive of the fate of the prosecution. The prisoner is substantially charged with forging a die or stamp used by the commissioners, with an intent to defraud the revenue. Now, in the first place, it is clearly proved by the gentleman from the Stamp Office that the whole of the stamp, except the words £2, is genuine, and also that the stamp has been issued from the office. I need not insist before your lordship that, to constitute a forgery, there must be an alteration or imitation of some material part of a die, stamp, or instrument. In the present case it is alleged that the £2 in the stamp which has been produced in court is not an impression from the genuine stamp. But in order to substantiate this charge, the prosecutors ought to have gone much further, and have proved that there had been an alteration in the value of the stamp. When the stamp was issued from the office, it must have borne some value, and for aught that appears in evidence, it might have been of the value of £2, and therefore I have a right to presume that it was of that value, and that whatever alteration may have taken place in it has only been a re-impression of the original words, denoting the value of it. Now, my lord, I contend that if this was the only alteration made in this stamp, the charge against the prisoner cannot be sustained. I will put a case. Suppose a man erase from a Bank of England note, a £5 note for instance. He obliterates, suppose by some chemical process, £5, and then impresses upon it the same value. This clearly would not be a forgery, nor could he be convicted, unless it could be proved that this note had previously been of a lower value, and this would be a case exactly resembling the present prosecution. There are two circumstances necessary to constitute a forgery: the counterfeiting or altering the material part of an instrument, that which affects its value, and the doing it with an intent to defraud. I contend, therefore, with great confidence, that neither of these has been proved in the present case, because no alteration affecting the value of the stamp has been even attempted to be proved, and that unless it can be proved that the alteration was of such a nature as to alter its value, and make it pass for a different sum to what it originally bore, the case on the part of the prosecution cannot be sustained, and the prisoner must be discharged from this prosecution. Mr. Scarlett dwelt on this point at considerable time, placing it in various points of view, and illustrating it by reference to similar cases. Mr. Littledale and Mr. Williams followed on the same side. Mr. Park, on the other side, urged that the objections could not prevail, and that the stamp having been altered in its essential part, that which gave it operation, the forgery was clearly made out. Sir Simon Le Blanc gave his decision in the following terms: I have been anxious to hear and to attend to all that has been offered in support of the objections taken by the counsel for the prisoner. The charge against the prisoner is substantially this: that by a false die or mark he impressed, or caused to be impressed, the resemblance of a die used by the commissioners on a parchment deed, with an intent to defraud the revenue. To this two objections have been urged. The first objection is, that evidence has not been given that the die of which this impression is alleged to be the resemblance was a die used by the direction and authority of the commissioners of the stamps; and the second objection denies that any forgery has been committed. With respect to the first objection, the court has already expressed its opinion, that there is evidence to go to the jury of the use of the die by the commissioners, and this is all that is necessary to be given in evidence. The Act of the 48 George 3, which imposes this duty, and the 52 George 3, which unites in one act all the laws inflicting the punishment of death for offences against the revenue laws, both agree in this. The 48 of George 3, in reference to this point, enacts that if any person shall forge or counterfeit, or cause to be forged or counterfeited, any stamp or die, which shall be provided, made, or used, in pursuance of this act or any former act, shall be adjudged guilty of felony, etc. The 52 George 3, after stating that if any person shall, after the passing of this act, forge, etc., any mark, stamp, or die, used by or under the direction of the commissioners, etc., goes on to add, or by or under the direction of any person or persons legally authorised on that behalf. The court therefore holds that the use by the commissioners is all that is requisite, and that of this use there is evidence to submit to the consideration of the jury. The court therefore does not consider this objection as valid. The other objection proceeds on the ground that no forgery has been committed, inasmuch as it has not been proved that any alteration has been made in the value of the stamp. It is contended that as a considerable part of the stamp has been proved to be genuine, it must have been issued from the Stamp Office, with words denoting its value. This value, for aught that appears to the contrary, may have been the same that is now impressed upon it, and that in fact there has only been a re-impression of the same words which were upon the stamp when it was first issued. And upon this assumption it is contended that, as no material part of the instrument has been altered, there has been no legal forgery. But it is unnecessary to give any opinion on the validity of this inference, because the foundation has not been laid, on which alone there could be a reason for examining it, there having been no evidence given to prove that this stamp was originally of the value of £2, and it undoubtedly lay upon the prisoner to prove this. For the case stands thus: there is a forged impression of a die upon an instrument, proved to have been in the possession of the prisoner, under circumstances which certainly call for explanation, and also in whose possession a number of dies are found, made too by his own order, and two of which appear to have been used to make an impression proved to be false and counterfeit upon this instrument. If these facts are not accounted for by evidence, or explained somehow or other, the presumption in law is, that this false impression was forged for the purpose of increasing or altering its value, and for the purpose of defrauding the revenue. This presumption thus raised, it is for the prisoner to repel by evidence, for there is certainly prima facie evidence to go to a jury. That the alteration of a material part of an instrument is a forgery has been solemnly determined by all the judges in a modern case, so that it cannot now be called in question. I cannot therefore on these grounds stop the cause from going on. The learned judge concluded by calling on the prisoner for his defence. Mr. Blackburn, who laboured under great and evident emotion, addressed the court and jury in the following terms: In the painful and anxious situation in which I am unhappily placed, I am ill fitted for the task of addressing you on this occasion. Agitated as I am between hope and fear, I can only solemnly assure you that I never forged a stamp in my life, but the public mind has been prejudiced against me by unfounded reports and advertisements containing vile insinuations against me. But, gentlemen, I entreat and charge you upon your oaths that you banish all that you have heard out of this court from your minds, and all that I have to wish from you is that you be influenced only by the evidence, and that you will do unto me as you would wish to be done unto, were you placed in my unfortunate situation. I have practised as an attorney among my townsmen and neighbours with credit and respectability for 27 years. You will hear from them, upon their oaths, the character I have maintained during that period. In making my defence I have many great, and indeed insuperable difficulties to contend with. I am called to furnish an answer, and by that evidence against a charge which I never heard of until I entered this court, for until I heard the indictment read I had no knowledge of that which they have imputed to me by this indictment, and of course it was absolutely impossible for me to be prepared with evidence to rebut the charge. With respect to the deed in question, I know nothing of it. It has been long out of my possession, and it is clear by the evidence of the witnesses for the prosecution that it has been very much exposed. I would only observe that if it had not a regular stamp affixed to it, the engrossing clerk must have seen it, and it must likewise have been observed at the office when the deed was registered. When my house was searched, my account books were taken away, which has deprived me of all means of tracing the deed in question, or of proving where the stamp was bought. I had therefore no clue to direct my search. With respect to the spoiled stamps, I would observe that they have lain by me a long time, and that the period of claiming the allowance for them has long elapsed. It often happens that, after a deed is engrossed, the execution may be delayed a very considerable time beyond the period allowed for the claiming of the allowance, and if ultimately it should not be executed, the stamp would be entirely lost. This will account for the spoiled stamps, which in a long series of time have been accumulated. I declare to you, gentlemen, that the deed in question had upon it a regular stamp when it was executed in my office, and I trust you will not presume anything against me, that you will attend only to the evidence, and that you will decide upon my fate with the same candour as you would wish in similar circumstances to have shown to you. My life is in your hands. I shall bow with resignation to your decision, and I trust that your decision will be right." As many as 24 gentlemen of the highest respectability were called to speak to the prisoner's character, and they all joined in declaring that they believed him incapable of committing such an offence as that which was imputed to him. The learned judge then proceeded to sum up the case, and the jury, having retired from the court for about a quarter of an hour, returned with a verdict of guilty. Mr. Blackburn and Mr. Wainwright were subsequently put to the bar together, and arraigned upon an indictment, in which they were charged jointly with removing a stamp from one deed and affixing it to another; but the evidence being inconclusive, they were declared to be not guilty. The court during the whole day was crowded to excess, and the greatest interest appeared to be excited among the inhabitants of Leeds, where the prisoners had lived, many of whom were present. Mr. Blackburn was dressed in a suit of mourning, with his hair powdered. He conducted himself with great propriety during the trial, but upon the verdict of guilty being returned, he appeared to be completely unmanned. He paid no attention whatever to the proceedings in the second trial, nor was he observed to take any notice of his fellow prisoner, Mr. Wainwright, upon his being placed by his side. Upon the Wednesday after the trial, sentence of death was passed upon the unhappy man, and on Friday the 24th of March Mr. Justice Le Blanc quitted York, leaving him for execution on Saturday the 8th of April. The interval was brief, and his friends determined to lose no time in applying to the Prince Regent for a mitigation of his sentence. A petition was accordingly prepared, praying for the exercise of the royal clemency towards him, and in the course of 2 or 3 days this application for mercy was signed by upwards of 3,000 persons, chiefly the fellow townsmen of the unfortunate prisoner. On Sunday the 26th of March, Mr. Elliot Carrot of Dewsbury, one of the attorneys employed in conducting the defence of the prisoner, went to London, for the purpose of presenting the petition to the Prince Regent, and of taking such other steps as should appear likely to contribute to the attainment of this object of the petition. Mrs. Blackburn, the wife of this unfortunate gentleman, also repaired to London, with the view, if possible, of throwing herself at the feet of his Royal Highness to supplicate for the life of her unhappy husband. Every means which zeal and friendship could suggest was used to give effect to this petition. Applications were made to persons of influence and consideration in the state, to secure their co-operation, but unhappily without success, and every hope of procuring either a mitigation or suspension of the dreadful sentence of the law was extinguished by the following letter from Viscount Sidmouth, His Majesty's principal Secretary of State for the Home Department. Whitehall, 1st of April, 1816. Sir, I have laid before His Royal Highness the petition which I received on behalf of Joseph Blackburn, a prisoner under sentence of death in the Castle of York, for forgery, and I am under the painful necessity of acquainting you that it did not appear to me consistent with my public duty to advise His Royal Highness to remit or suspend the execution of the sentence passed upon this unfortunate person. I have the honour to be, Sir, your most obedient servant, Sidmouth. Before the result of this application to the Prince Regent was known to either the prisoner or to his friends at Leeds, it was deemed advisable to submit to Mr. Justice Le Blanc, who was then at Lancaster, certain affidavits. The object of these affidavits was to show that the deed was executed on the day it purported to bear date, which was on the 30th of September 1812, and that as the dies spoken to by Mr. Topham were not delivered at the office of Mr. Blackburn until the following month, it was quite impossible that any forgery of the stamp on the deed in question could have been made by him at the time it was executed. This application, like that to the Crown, was unsuccessful, and the unhappy prisoner, having received an intimation that no hope remained that his life would be spared, he proceeded anxiously and ardently to apply himself to his religious offices. He was attended up to the time of his execution by the Rev. John Hamilton, the minister of a dissenting congregation at Leeds, to whose religious exhortations he paid the utmost attention. He continued for some days to labour under a despondency approaching to despair, arising, as he himself stated, not from the dread of temporal death, but from a deep consciousness of the aggravated guilt of his past life, his total neglect of religious observances, and his gross indulgence in forbidden sensual pleasures. He stated that the irregularities of his past life had been so great as to have deserved that death which had been awarded against him for an offence of a different nature. He added that these crimes had been committed against light and knowledge, and that he had only repented of them and thought upon religion when every pleasure had been cut off and every earthly hope had become extinct. We rejoice, however, in being able to add that in a few days some faint rays of hope penetrated the gloom which oppressed his mind, and as the merciful provisions of the gospel were unfolded to him, and its encouraging promises pressed upon his consideration, these hopes became brighter, and cast, if not a brilliant, yet a cheering ray of light on the gloomy path he had yet to tread. On the Thursday, the 6th of April, he attended the chapel, and heard with profound attention a sermon preached by the Reverend Mr. Richardson, who had some religious conversation with him after the other prisoners had retired. On Friday afternoon the prisoner had a last interview with his brother. His unhappy wife had come to York on the same painful errand, but on Mr. Hamilton representing to her that an interview might disturb the tranquillity of her husband's last hours, she abstained from pressing the request which she had made. She had seen him only once since his conviction, and the meeting was of the most distressing nature. On the night before the execution, Mr. Hamilton continued in prayer with the wretched prisoner up to a late hour, and he repeatedly expressed himself perfectly resigned and ready at any moment to meet his fate. On Saturday, at about 11:30 o'clock, Mr. Blackburn was called from his cell, and the necessary arrangements having been made, he was conducted to the scaffold supported by Mr. Hamilton. He walked with a firm, unhesitating step, and perfectly erect. It was a quarter before 12 o'clock when the procession arrived upon the platform. The prisoner immediately kneeled down upon a stool provided for the occasion, with his face averted from the numerous spectators who were assembled to witness this sad and melancholy spectacle. The reverend gentleman who had with so much zeal and unwearied assiduity attended him in prison, to speak to him the words of peace, did not shrink from the painful task of accompanying him through this last painful stage of his earthly pilgrimage. Placing himself near the prisoner, he, in a low tone of voice, asked him some questions relative to the state of his mind with respect to his approaching change, and particularly with respect to his entire dependence on the mercy of God through the merits and mediation of the Messiah. To these inquiries he replied, "I have no other, I wish no other trust." Mr. Hamilton now inquired if it was his wish that he should pray with him, and he eagerly replied, "If your feelings on this occasion are not too much agitated, I shall be greatly obliged." Kneeling down close to the prisoner, who kept his eyes closed during the whole of this sad solemnity, he then offered up a prayer at once solemn and tender, and adapted equally to the former character and present situation of the humble penitent before him. Mr. Blackburn appeared deeply to feel and fervently to join in this last act of devotion, and when the minister came to that comprehensive model of devotion, the Lord's Prayer, the prisoner accompanied him in an audible voice. When Mr. Hamilton rose up from prayer, he took Mr. Blackburn by the hand, and having commended him to the mercy and protection of the Almighty, took a sad adieu of him, conjuring him that when he suffered death, and was entering eternity, he should aim at no higher strain than this: "God be merciful to me a sinner." The poor sufferer grasped his hand, and appeared reluctant to part, and in a voice rendered tremulous by emotion, said, "May Almighty God bless and protect you." It now only remained for the executioner to perform his part in the heart-rending ceremony. Mr. Blackburn was assisted to rise, but it was evident that the powerful emotion of his mind had impaired his strength, and the under gaoler supported him in his arms until the fatal cord was placed around his neck and properly adjusted. At this awful moment he ejaculated, "O Lord God Almighty, have mercy upon me, and preserve my soul alive." These were the last words he was heard to utter as the drop instantly fell. It is painful to add that the noose of the cord had, by some means or other, slipped from its proper situation, and he appeared much convulsed. After he had been suspended about 2 minutes, The executioner endeavoured to replace the cord in its original situation, and though he succeeded in this attempt, it seemed to harrow up the feelings of every person present, and produced a stronger sensation of distress than any part of this mournful ceremony. In about 6 or 7 minutes from the falling of the drop, the unfortunate man appeared insensible of further suffering. The body, after remaining suspended the usual time, was put into a coffin and delivered to his friends. His remains were interred at an early hour on Monday at Rothwell, a village near Leeds. End of Part 82.